Welcome to everyone to today's webinar, Transition to Adulthood. I'm Diane Brenneman, and I'm happy to have you join us today. There's a welcome sign in many languages. Our training is sponsored by Child Health Specialty Clinics and the Iowa Regional Autism Assistance Program, both a part of the University of Iowa Stead Family Children's Hospital. Also sponsored by the Iowa Developmental Disabilities Council, or we call it the DD Council, and Iowa's University Center for Excellence in Developmental Disabilities. I'm happy to have Frank Varvaris here today, and he's going to be presenting on estate planning for your child with disabilities. Just a few logistics. If you have questions, we encourage you to type them in at any time during the presentation in the question box. And when Frank finishes the bulk of his presentation, we'll take questions for him. Use the chat box if you have technical questions for the producers, and we'll assist you. I also want to draw your attention to a handout that Frank has prepared for us, Legal and Financial Rules of the Road. And you can see in your toolbox there, your toolbar, where the handout bar is. And if you click that, you'll see that. If you have trouble downloading it, just shoot me an email after the webinar and I'm happy to attach it. Okay, as Frank pulls up his slides, I'm going to introduce him. Frank Varvaris is the proprietor of a firm in Cedar Rapids that's been providing estate planning to people with disabilities and their families since 1990. His office also assists consumers with Social Security disability claims, home and community-based services waiver applications, and assistance with Medicaid and Medicare. Frank pioneered special needs planning in Iowa over 30 years ago and wrote Iowa Code 634A, Protecting Special Needs Trusts. He currently is serving on the Early Childhood Iowa State Board. Welcome, Frank.
Thank you very much, Diane. It's nice to be back. I enjoyed presenting last Friday, the 23rd. Today, I have the opportunity to also present. The topic that I'm going to cover today is basic estate planning to provide for your child with a disability. This is going to be an abbreviated version. The actual presentation can take up to an hour to an hour and a half when I'm explaining to parents the proper estate planning strategies to use for your son or daughter who has disabilities. This is going to be the abbreviated version. It's going to be much shorter, but hopefully you'll have enough information that you can start doing some of the basic estate planning yourself to provide a continuum for your son or daughter's future. I would like to mention that yearly, my office sends out updates on the Social Security cost of living adjustment, of which we have one this year that will go into effect January 1st, a 1.3% increase. And so I would encourage attendees, if you would like to access one of those sheets from our website, you can do so next Friday. And my website that I will steer you toward is www.disabilityplanning.org. And on that sheet, it will have the changes in the SSI benefit, SSDI benefits, the extended period of eligibility, the trial work period amounts, things like that, that you can refer to as a handy sheet when you are working with clients, or if you are a parent of a child with a disability, you can see what your child's income will do to impact the benefit that they're receiving from SSI or SSDI. Okay, I'm going to talk today about basic estate planning to provide for your child, as Diane had mentioned. And I'd like to clarify the work that I do. I am a planner. My office is not a law firm, a tax agency, an agency of the state of Iowa, or of the federal government. My office is an approved provider through Social Security's Ticket to Work. I'm referred to as an EN, an employment network. And furthermore, my office is not owned by or part of any subsidiary of a bank, insurance company, investment, or financial services organization, and we have absolutely no captive relationship with any of these entities. Today's topics that we will cover: basic estate planning, as Diane had mentioned at the onset of this presentation. And then we'll also discuss financial, safeguarding money for your child and using a life enhancement disability trust, formerly called a special needs trust, to hold that money for your child so that it can be used for their future. When families plan for their child, they oftentimes want some types of clarity in understanding the rules. And the rules can be complicated because a lot of the programs and services that are provided to a person with a disability through county, state, and the federal government, they seem to have different eligibility requirements. Most programs follow what's called the $2,000 resource limitation. Other programs follow a higher resource limitation, but at some future date or age, that resource limit can change to only $2,000 again. Eligibility guidelines for services may differ for county and state and for the federal benefit programs. Income guidelines for some assistance follows the 300% rule, which you may or may not know what that means, while others do not. And then lastly, some benefits are means tested while others are not. So it can be difficult for a family to develop a program or a continuum to meet the needs of their son or daughter with disabilities, because you have to understand the eligibility requirements for those programs and services. And oftentimes the family will come into our office and I'll say, where did you start? And they'll say, well, we started with Social Security, and then they recommended we go talk to the Department of Human Services. From there, we went to a nonprofit. We met with an attorney. We looked and talked with a CPA because we wanted to make sure we were minimizing tax consequences. From there, we talked to a financial advisor, a bank. Well, by the time it was said and done, the family didn't complete the program of planning because they got overwhelmed in the process. So what I recommend is think about, and there are experienced planners out there that you can consult that can coordinate all these different entities for you to take you through this in an expeditious manner so you can get everything done. It's comprehensive and it meets the needs of your child. In the end, the idea is parents deserve peace of mind knowing that they've done their planning. Let's start by talking about government benefits first. Now, I mentioned earlier that a lot of the programs out there follow the eligibility methodology for Social Security. So I'm going to give you a little background about the Social Security entitlement, which there are 4 parts. And if you attended the meeting last Friday, I went through this same slide, but I think it's important to go through the slide again so that everybody has an understanding of what is provided. The Social Security entitlement was signed into law in 1935. And that entitlement, way back then, called Title II, created this trust fund that held sacred money for wage earners, people that worked, paid into the system with the idea that eventually they would reach age 65 and receive a lump sum payment so they would have enough money to live on at retirement. That's not the way it works now, but that's the way it began. If you are an individual age 65 or older, you are eligible for a health care component called Medicare, Title 18. Now, how do these work? Well, if you are an individual working, you receive a paycheck from your employer. The employer made the FICA deduction from that check. You match it, your employer matches it, sends it up to Baltimore, Maryland, and then when you retire at a given age, based on your earnings, the age of which you retire, and a couple of other things, you receive your income from Social Security Title II, and if you're 65 years and older, you receive Medicare health care coverage. In 1956, the government figured out there are people that work, pay into the system, but they can't keep the pace and persistence of holding that job because they have a disability. Could be mental, physical, or a combination of the both. So what Congress did is they amended the Social Security Act Title II and created a window of opportunity for families to provide for their dependents through Social Security for disabled, SSDI, which is Social Security disability income, and it opened up another window of opportunity called Social Security for a disabled adult child. And what that does is it provides income to a breadwinner who is disabled. It provides income to dependent children of a wage earner who is disabled under the age of 18. And it also provides income to children that were found to be disabled themselves prior to age 22, so that that child can receive benefits based on the earnings record of that parent. In 1972, the government figured out, hey, there's another benefit we should have for people that do not have an earnings record. Some of the children that come out of transition centers, they don't have a lot of earnings record, but they have a disability condition that Social Security would determine to be disabled and provide benefits. So they created, Congress did in 1972, supplemental security income called SSI, Title 16. And in Iowa, if you are an individual receiving any supplemental security income, you receive Medicaid Title 19, which is the big ticket item for an individual who has a disability. The income maximum SSDI payment for a person with a disability receiving Social Security disability income is $3,011 per month. The maximum federal benefit rate for an SSI recipient is $783. So there's quite a difference between the two benefit packages that are provided. In either of these, at the lower based on assistance, SSI and Medicaid, the individual can have no more resources than $2,000. If they go over the $2,000 resource limitation, they lose their benefit. So the question is, and you can ask yourself this, if you are an individual working with the game plan that at some point you're going to retire, and you could only have $2,000 of countable resources to your name when you retire, that could be a scary situation. Well, that's sort of what we're asking people with disabilities to do, to stay below a $2,000 resource level in order to maintain eligibility for Supplemental Security Income, Title 16, and Medicaid. Now, knowing that your child must follow guidelines, consider the options. Because we want to make sure that the child has no more than $2,000 in resources, some parents think about disinheriting their child and leave him or her nothing. Families think about that. They say, well, we want to be fair to all, so we are going to leave an inheritance directly to our child. What happens? We're over the resource limit, child loses their benefits. The third option parents can consider is leaving inheritance money to another sibling or relative, hoping that that person, when they receive the inheritance money, will use it for their child with disabilities. And that is one strategy that families can use. I encourage families to think more about that closely, because if in fact you have a son or daughter who receives an inheritance from a parent's estate and they're going to use it for their brother or sister who has a disability, that money becomes part of their estate. So if they're driving down the street and they rear end somebody and there is a lawsuit against that child, that money's at risk and could be spent down in a lawsuit settlement. Beyond that, if the individual that inherited that money receives it and they have a health problem of their own and they end up going into a nursing facility, the monies could be spent down for Medicaid purposes. So we really didn't set out to accomplish what we wanted to do. Fourth thing that you can consider is have your attorney draft a trust for your child. And make sure the attorney is astute and understands what types of trusts should be developed for a person with a disability. The fifth one is leave inheritance money for your child in a carefully crafted life enhancement disability trust, which is similar to the law that I wrote years ago, Iowa Code 634A, with certain safeguard provisions. I recommend that parents follow, if they're planning for their child's future, 5 simple steps. And we take the parents through each one: futures planning, determining in advance what it is that you want for your child's future; financial planning, is what we want financially attainable? And I'll share this with you. I have a client that lived in a small town near Victor, Iowa, 6 children. 3 children graduated from college, did very well. And then mother had 3 children who have disabilities. 2 boys have Fragile X, which is fairly severe, and ADHD on top of it. So they have developmental disabilities that they were born with from birth. And then she has a daughter who has physical disabilities, and her physical disabilities came into existence when she was in her early 40s. Well, the package of benefits for the boys are totally different for the package of benefits that are for that daughter who has physical disabilities. And mother's goal is to keep her 3 children in the farmhouse living in this small community. The financial planning aspect is important because I didn't want to leave this goal to pipe dream for the mother, thinking that, hey, I've got everything taken care of because government benefits are going to take care of my 3 children, when in fact they won't. Government benefits aren't going to pay for the upkeep of the farm. taxes, insurance, and all the other things that go along with that, plus the upkeep of the house. So we needed to work backwards and determine how much money do we need to provide for these three children if in fact they're going to continue to live in the house. And then beyond that, finding a provider that would come in and look after their needs. That is difficult too, because there's not a lot of not-for-profit residential providers that will provide support and care if they're not going to make any money. So monies have to be available to pay for those things if in fact we want that service to continue to be provided. Legal planning should be looked at and should be addressed. Program finalizing, and then maintenance planning. I'm not going to go through all of these different steps, but briefly I'm going to talk a little bit about step one, which is a very important part of this, futures planning, and explain what it entails. I recommend when parents begin planning for their child who has a disability, they pull together as a family unit, take out a legal pad, and they write down these various categories. The first one we would write down would be future living arrangements. Now, if your son or daughter lives at home, mom and dad typically are that child's care provider. You know more about your child than anyone else. At some future point, your child may transition away and live in a community-based setting with other providers that look after his or her interests. The point is, as your child transitions away, excuse me, other providers may look after their care and supervision, but if your child gets into a pickle, mom and dad are still there to come to the rescue and salvage whatever they need to do to make sure their child's needs are met. The question is, if you're no longer in the picture, who'll step forward? Employment or meaningful day activities should be discussed openly for your child. And let me share this with you. I have a client whose son's living at home, works all the way across town in Cedar Rapids, Iowa. Mom takes the son to work. He works on a part-time basis and then picks him up at the end of his shift. We figured out that if mother was no longer in the picture and this young man had to pay for Uber, taxi, or whatever, it would cost him $15 more than what he's earning in income on a monthly basis. So we discussed that and decided, you know, we're going to make sure that we have available money to take care of this, because that gives this young man a purpose to get up in the morning, to go to work, to meet and have a circle of friends with which he can converse, comes back home. He's doing something purposeful that is quite meaningful. So we want to make sure that that continues. Social leisure activities should be addressed, categorized, and then options listed. What are those things that your child enjoys doing socially or alone? Medical care, personal needs assistance, religious environment, final arrangements. All of these should be addressed, categorized, discussed openly with all family members. And I believe that if your child is capable, he or she should be part of this planning too, because it's their future that we're talking about. So we need to take a look at your child's unique qualities and characteristics, including their likes and dislikes. Excuse me. And if your child can participate, let's make sure that we are doing so. I believe when we are doing person-centered planning, we have three components of support: the planner, the legal practitioner, and the family. All of those are working in tandem in order to create the continuum to meet the needs of the individual who is the person, because that's, excuse me, that is the most important part of this program. Let's talk about how to protect your child's future by safeguarding money using a third-party life enhancement disability trust. Formerly, I used to refer to this as a special needs trust. Now, when I wrote the law in Iowa years ago, I did so because a lot of the attorneys with whom I was working didn't have a clue about trust for a person with a disability. And I thought, you know, if I can at least draft a bill and I can get a sponsor to help sponsor this bill and we can get it through, then we have Iowa code on the books and legal practitioners can go to a reference to see, hey, this is a bona fide law. We can do this and it will protect trust for people with disabilities. It doesn't mean that the attorney is going to craft a well drafted trust, but at least we've got the law. Subsequently, I've determined that the Life Enhancement Disability Trust is the next generation over and above the Special Needs Trust because it allows for things that are much more flexible in providing disbursements for the person with a disability. The Life Enhancement Disability Trust protects government benefits because, excuse me, it protects government benefits because it is not deemed to be an asset that belongs to the individual if it is drafted correctly, provides for supplementary needs for the person, and then over and above that, it provides flexible discretionary language that will allow for expenditures that may even affect government benefits. But the trade-off is if that expenditure from the trust affects a government benefit but enhances the life of the individual, so be it. We need to weigh the pros and the cons of making that expenditure and seeing what the life enhancement will do in order to help that individual enjoy life. And then lastly, the trust assures the quality of life that's safe and meaningful, which is most important. This is the estate planning distribution. And in the slide, I'm showing a smaller estate. Mom and dad have $225,000. I'm not suggesting that's small, but it could be smaller than a lot of the estates that are out there. And the reason I use this is I don't want families to think that they have to be affluent in order to do proper estate planning for their son or daughter. In this scenario, hypothetically, we have an estate worth $210,000 after probate. Mother and father have 3 children. Loving each child equally, they divide their estate equally with three kids. Child A receives $70,000, child B $70,000, the child with the disability received $70,000, but what happened? They lost all their benefits. because they're over the $2,000 resource level, at which time they go on a private pay basis. All of that money is spent down. Finally, when it reaches $2,000, the individual is impoverished again. They restore benefits, but there's nothing for that individual to have to fall back on if they get in emergencies or if government benefits are cut. This is the way it can and should look. Same example. Parents have 3 kids. In this example, they left equal shares to each child. Child A, child B, both received $70,000. The child with the disability, their $70,000 went to the Life Enhancement Disability Trust. Monies were used to supplement what the government provides, step in emergencies, used to enhance the well-being of the individual. And then, because when parents create that trust, they name the remainder beneficiary at the death of their child. So when their child dies, typically, the remaining monies can go to the remaining 2 siblings. And then 99% of the clients with whom I work will leave a portion of the money in their child's Life Enhancement Disability Trust to a nonprofit. It's a painless way of earmarking proceeds that could go to a nonprofit organization that has served your child well. The carefully crafted Life Enhancement Trust provides for supplementary needs, but the trustee must be given complete and unfettered discretion to disperse more funds if government benefits are cut or in emergencies, or if the trustee determines that the current benefits provided by the government are not suitable or do not enhance the beneficiary's right to live and enjoy life to the fullest extent possible, just like you and I would want to live. The trustee may then use trust funds to supplant government benefits if necessary. Who manages the Life Enhancement Trust? The trustee that you appoint. And normally what happens is families will have the trust created by their attorney. They are the initial trustees that manage any monies that are deposited into the trust account. At some future date, parents pass away, the trust becomes fully funded. Successor trustees then step up to become responsible in managing that money, the corpus in the trust, and using it to the fullest extent to provide for your child's future. If you're going to consider corporate trustees, I recommend that the family ask questions. How often do you meet with each child? And where do you usually meet with him or her? And that's an important question, because I'll have families that are thinking about appointing a trustee, and we want to make sure, is this individual that works at that financial institution, are they actually going to leave the office, go out and maybe break bread with this individual that's living in a group home, getting to know their needs and the staff that are providing care? It's important to have a sensitivity to their needs. Ask questions like, do you ever meet with the child service providers? Attend habilitation meetings, Review and compare MCO coverages options to determine which one is most comprehensive, and then visit with our child's case manager, and if not, why, and if so, how often? We would want to know those things. How much of the trust money do you typically spend for a child over a 12-month period? When do you furnish an accounting and expenditures to the beneficiary to his or her guardian or to a trust protector. And I'll talk about a trust protector in a moment. Let me share this with you. I have had referrals from the University of Iowa Law College, Professor John Allen and Len Sandler. And I received an article from Professor Sandler not too long ago that stated trustees should be aware of their responsibility of serving their person, the beneficiary of the trust that they are administering. And in that article that he had sent to me, it talked about this individual, an attorney in 1997, who did an estate planning for a mother of a child with autism. The attorney drafted back then a special needs trust, named himself and J.P. Morgan Chase as co-trustees. Later on, the mother of the child died, and the trust became fully funded with her estate assets. And the estate assets at that time were roughly $2,700,000. Well, what happened was the attorney wanted to become the guardian for this young man who had autism. And so he approached the court and said that he would be the appropriate guardian because he's already managing this trust for this young man. And the judge said, let me see that trust. What type of monies have you been using from this trust to help create a life enhancing for this individual? And it turned out he had never used any of the money, and over 10 years, it had grown. And as a matter of fact, the judge said you need to start using this money in this trust if you aren't actually appointed as the trustee. And that was directed at both the attorney and the co-trustee J.P. Morgan Chase. In 2012, the trust had grown to $3,700,000. So obviously J.P. Morgan Chase made out very well. Over that 5-year period, the co-trustees eventually spent $3,525 for the child at the advice of a care manager that they hired because they weren't going to go out and see the child. And they charged the trust $78,000 for all this hard work. So both trustees, Harvey Platt and J.P. Morgan Trust, or J.P. Morgan Trust Bank, made out very well. The reason I share this story with you that was sent to me by Professor Leonard Sandler is because I believe it is important for families to put in some protective language that can monitor the responsibilities and the obligations set forth in the trust and given to future trustees. And we call that monitoring entity a trust protector. The trust protector, I have a corporation, Life Planning Administrators, that provides that, but I won't get into that. You can name any individual or entity you want. The trust protector can step in if there are irreconcilable differences that occur between the trustee and the beneficiary, or the trustee and the guardian, or the beneficiary and the guardian. The trust protector can step in if the trustee rarely contacts the beneficiary. Maybe the trustee is inattentive to the beneficiary's needs. Trustee doesn't spend money. Trustee doesn't return phone calls or is always busy. Trustee never gives immediate answers. They always have to talk to the legal staff and then respond within 2 or 3 days. Well, if there's an individual that needs a winter coat, we don't want to wait 2 or 3 days for that expenditure. We want the monies to be available immediately so that we can use it to help enhance our individual with the beneficiaries or the person's life. Corporate trustee, a bank is sold, transfer services to a new distant location. The trustee does not share tax or accounting information. The trust protector can step in and monitor this. What can the trust protector do? They can amend trust provisions to ensure that your child's trust will meet guidelines and correct scrivener's errors, review disbursements and accounting, provide trustee with direction, help ensure money is used for the child appropriately. They can take over as an interim trustee. They can take over as a full trustee. So you have a backup involved. If the trustee is not doing their job, the trust protector can step in. And we have clients, frankly, that they'll begin as trustee of a trust and they don't want to do it anymore. Maybe they're having trouble with the brother and it's difficult for them. They're sensitive to their brother with the disabilities needs, but they want somebody to be a third party once removed to kind of help them with that management. The trust protector can step in and do that. This is the quality of life slide. It shows what the government provides on the left-hand side: care and supervision, room and board, medical care, employment opportunities through the Iowa Vocational Rehabilitation Services and agencies that serve the people with disabilities in the employment field, basic personal needs provided through SSI, state supplemental assistance, Medicaid, Medicare. And then on the right-hand side, we have what families or parents typically provide to their son or daughter, and that the life planning, life enhancement trust can continue to provide with written instructions with the letter of intent to make sure that their child's needs will be met. An advocate guardian to look after the person's best interest if needed. Additional medical care, dental care. Now I have this may not sound like a big deal, but it really is to me and to the client. I have a client that their child needed to have a tooth repair. Well, Medicaid wouldn't pay for it, but they paid for the extraction of that tooth. So this young lady, she's got a gap in her mouth. Her self-esteem is being affected a little bit. And I understand that. So I'm sensitive to that myself. Monies in the trust can be used to pay for the cost of appropriate dental care. Vacations with relatives, gifts on special occasions, self-esteem items, basic care, if there are government cutbacks, all of this can be provided through the Life Enhancement Disability Trust, accompanied with your letter of intent to help provide direction for the trustee to meet the needs that it is and the goals that you want for your child. I threw in a couple of extra slides here that I thought might be helpful. One is repositioning assets. I'll have clients that went to a seminar and somebody's talking about moving monies around to qualify for Medicaid and related services. Be careful because there is a 5-year look back, and state Medicaid recovery can go back after those entities to whom you give money away. Medicaid compliant annuities can be used. I won't get into that, but I will talk about this. If you have a child and you want to apply for insurance for your child, this is the first thing, make sure that you are applying with carriers that have very liberal underwriting standards and will issue a policy without having to deny coverage, and then that code goes into the Medical Information Bureau in Chicago, Illinois, and then your child reapplies with another carrier. That code is there. It adversely affects the underwriting for your child's coverage if in fact you want to get insurance. The other thing is, I had a client that was referred to my office a number of years ago. Her son, 29-year-old young man, was injured in a car accident and sustained traumatic brain injury. Mother was trying to get her son eligible for a waiver so that he could stay in an apartment because she didn't want to have him go into a nursing home setting for which she thought that was inappropriate. So she met with the income maintenance worker through the state, and the income maintenance worker said, your son's not going to qualify for any waiver services or benefits or Medicaid because he's got this $100,000 life insurance policy. It's got $4,500 of cash value in it. He's over the $2,000 resource level. So what they've suggested is cash in the policy, put the $4,500 into an irrevocable burial trust, which you can do, and then he can qualify. So the mother came into my office and said, what do you think of that? And I said, well, I don't like it because we're taking this big insurance outfit off the hook for this large $100,000 insurance payment. And he'll probably not get standard insurance again. So here's what we did. We transferred the owner of the insurance policy to the mother. Now that's a no-no because that's called a transfer for lesser than fair market value. DHS doesn't like that. So we had mother take the $4,500 out of the policy, give it to her son. Son still doesn't qualify, but because he could keep $2,000, he put $2,000 in his savings account, and then mother went out with the $2,500 excess, bought him a computer and some programs to engage his mind. That made much more sense. So the reason I share this story with you is sometimes mom and dad will meet and get some advice from a bureaucratic staff person that looks at their book and said, well, you can do this or that. And that is right. You can do this or that, but it may not be exactly what's going to benefit your son or daughter. So I always tell clients, get a second opinion if it doesn't feel right. I'm open to questions, Diane.
Thank you, Frank. We do have some for you. Amy wants to know, she says, I have a special needs trust written up through an attorney, but I haven't set it up at a bank yet because I don't have extra income to contribute to it at this time. Should I still set it up at the bank with a small amount so it's in place?
If you are the trustee of the trust, you can fund it with $10, and you would put that down as you have funded the trust with $10 on this day, October 30th, 2020. Money is held in, you can say your safe deposit box, whatever you want. If you decide you want to open up an actual account at the bank and have it run from the trust EIN, which is the employee identification number, you can do that, but it's a step that you don't have to do if in fact you're only going to fund it with just a small amount of money.
Thank you, Frank. Another one from Margaret. If a parent puts inheritance into an ABLE account, would the child lose their SSI or SSDI?
No, you will not. But be careful putting money in the ABLE account. What happens is that money at death of the individual, the state will go after and make claim for reimbursement for Medicaid expenses paid on behalf of the individual. So that money's sitting there to reimburse the state at some future date. You might want to consider a couple of other things. One could be maybe using a Medicaid compliant annuity. One could be looking at a self-settled trust. One could be taking that money, having it paid to parents for living expenses, transportation costs, and things like that. And then once that money is in the parent's hand, you can actually create the Life Enhancement Disability Trust because it's funded with money that belongs to you, mom and dad, not your child.
Thank you. Another one from Dawn. Can the Life Enhancement Disability Trust process be done completely with Frank, or is there an attorney also needed?
You need an attorney. And then what I typically do is anything for our clients, I get a copy of anything that the attorney drafts, and I go through it and make sure that, it's not necessarily boilerplate. Each child is different. If you've got a son or daughter that has a mild disabilities, they're working at Goodwill, that child's needs are different than the individual that has a traumatic brain injury and they're in bed 24/7. So we don't want to have a boilerplate. We want to make sure the language impacts favorably for whoever that beneficiary is as it relates to the trust.
Good. We have about 7 more questions. Can a life enhancement trust be used to buy a house or condo for a disabled person?
Yes, it can.
Okay. And are life enhancement trusts portable to other states, or are they specific to Iowa?
They're portable.
And can we transform an existing special needs trust to a life enhancement disability trust, and how?
Good question. You might be able to, if you can, if your current trust is not irrevocable, then of course you can change it, modify it, amend it, do about anything you want. If it is irrevocable, depending on the language in the trust, you may have to get court permission to do so, but I would say you would have a good chance of doing it.
Super. I have a child, this is from Nick, with special needs, and I have a special needs trust written in my will. Is that enough to set up the trust at the bank? And how much is reasonable amount to start the trust?
Good question, Nick. I believe the trust should be an inter vivos trust. It's separate from the will. It may not be fully funded now, but it's separate. So we have this separate trust. It has its own employer identification number. You fund it with a small amount of money now, and then you make the decision if you want to add more money and set up an account at the bank. When you have a trust that is part of your will, it's not separate. It only goes into effect when you die. So when we're doing continuum planning, one of the things that we do, and think about this, Nick, grandmas and grandpas sometimes will say, we're going to leave money to our grandson, but they can't do it if it's in your will. You have to die first. So maybe the inter vivos trust is what we want, because then we can notify grandmas, grandpas, aunts, uncles. We're not suggesting you leave anything to Tom, but you did say you were going to provide for him. We have this trust that's already been created. October 30th, 2020, The EIN number is this. It's called the Thomas Jones Life Enhancement Disability Trust. Please don't leave anything directly to Tom. Leave it to his trust. That's the way we want it set up. Does that make
Another,
sense?
yeah, another one. Are parents of a disabled adult child able to leave that child land and rental income from the farmland?
They can, depending on if the child is SSDI eligible. If the child is SSI, then we're going to destroy the income and the asset base. So I'm not a big believer in having a person with a disability that's receiving Title 19 own a lot of land and farm property with income, because they can lose their entitlements. And then you have the state of Iowa that can become a partner. I'm more comfortable having that asset go into the trust
Yeah,
and some other options.
right. Elaine would like to know if there's a list of lawyers in Iowa that have this expertise to write an LEDT. And if you could provide something like that to me, Frank, I can send it to the folks after the webinar. Or is
Um,
there a place to look that's easy we can type in now?
you know, there's more and more attorneys that are getting involved in special needs planning. And, you know, you could probably type it in and you'd have a dozen or so come up. Um, I usually I will refer clients to an attorney, have them meet with the attorney first, see if they like him or her, and then I send the attorney a letter stating what we've done and what we need him or her to do.
Great, great. And that handout that we provided today has Frank's contact information if you'd like that. Um, Madeline would like to know, how did the family with the 3 kids and the farm living in the house, how did they cover taxes and utilities for the home that was already owned? Could a
Uh,
life enhancement disability trust be used for this?
it can.
Okay,
Yep. As a matter of fact, the disability trust will inherit the house and they'll live in it, and the disability trust pays all the upkeep, insurance, taxes, and everything else.
okay. And one last question from John. Any advice on 529 ABLE accounts and the role they should play in estate planning?
Yeah, I think that
Talked about
they
this a
are,
bit.
if you have a child that is fighting the $2,000 resource level constantly, they can divert some of that money into the ABLE account. And then they can use that money from the ABLE account for things that theoretically are related to their disability conditions. And that's now, I believe, is it going to enhance their life? And that's what we look at. And if it is, then the monies can be dispersed. So did that answer your question?
I think, Frank, you've done a great job of helping us with this complicated topic. Your care and concern for our children is obvious in the way that you speak, and I really want to thank you for your time and the way you so carefully sketch out our options in estate planning.
Thank you.
It's it's time to wrap up now, and I just want to show everyone that next week, Derek Willis, the director at Iowa's Youth Said, is going to talk with us about how to promote self-determination within our youth, how to help our youth speak up for themselves and advocate for themselves. He's worked quite extensively with youth, and I think you'll really enjoy that presentation. Following up on the 13th of November, Jennifer Donovan will talk about guardianship and shared decision making. Then we're going to have a special um, event where Judy Worth will have some youth and their parents who have been through transition talk with us about their experiences. And finally, we'll get to view a Intelligent Lives documentary about a young man who's lived through transition and is enjoying a good life. So thank you for your participation. If you do want to reach out for help or additional resources, we have family navigators that you can access with my email there. Or if you have school-related questions, you can reach out to a family educator partner with Susan Selby's contact information. An evaluation link will be coming to you from GoToWebinar, and we really do read those and appreciate your suggestions for the future. Thank you for your time and for joining us today in this important topic. This will end the webinar now.